We are back in Senate Judiciary, April 3rd. We have page 44 and then council with us. We had a lively discussion about the change that's on page 5 as passed by the House version. And so I think that perhaps we can just do some level setting and revisit that section. See what, if anything, we should be doing. And yeah, that's more or less it. And if you want
No, I mean, I know that yesterday, I've been, for the record, Ben Oberossi from the Office of Legislative Counsel. I know yesterday there was, as you said, Mr. Chair, a lively discussion. And I know that the word hinder was suggested as a potential replacement for refuse. So that's, you know, a consideration that could be made. You know, I think just given the testimony that the committee heard yesterday, I think regardless, as Judge Zoney testified to, regardless of the change of name, these are issues that are going to be litigated. This is a statute that is often litigated anyway. It's about implied consent and the process of gathering evidence for a DUI stop and all that, so that those are commonly litigated issues. But I just want to reiterate my testimony from yesterday, which is, you know, under a Fourth Amendment analysis, the warrant requirement is sort of the presumption in a way. And then you have exceptions to that requirement, one of which is consent. And so I think from my perspective, for the committee to consider, they're really two separate analyses. Whether or not someone has consented to a search and whether or not a warrant has been issued. Because if a warrant's issued, that means there's been a judicial determination that probable cause is supported to investigate further. And so you don't need consent once you have a judicially issued warrant. Now, if you want to adjust language to kind of help make that distinction a little bit clearer, I think that's within the committee's prerogative. But consent, in my view, is a separate analysis from the warrant.
So I think one of the issues is that in the event that somebody does physically resist when there is a warrant issue, they're getting charged with a felony. Whereas this is proposing to charge them with criminal refusal, which is a misdemeanor, correct? But it's also my understanding that with that implied consent doesn't apply to drawing blood, right? And so since implied consent doesn't exist there, if somebody initially says no and there's no warrant, that's not something that can be punishable.
Correct. And there's been case law sort of about what's called the unconstitutional conditions doctrine. So essentially that is, you can't kind of create a Sophie's choice for somebody because it's not a true choice at that point. So if you say, well, you need to consent to this blood test or I'm going to charge you with a crime, the courts have opined that that's not really a true choice. It's coercive in a way. And so that's why, at least when it comes to something that's as intrusive as a blood draw, really can't threaten that criminality or refusal to consent to it. And so the implied consent, that's why there was all that discussion about a breathalyzer being less intrusive and more really interactive because it requires action by the subject. And that's where implied consent comes in. But its scope doesn't cover a blood draw due to its intrusive nature.
Any questions?
That's a quick one. The individual was involved in an accident, is incapacitated to respond and go to the hospital. Say law enforcement has reasonable suspicion of the beyond that, they say that they need to draw blood. and they don't have that to consent one way or the other. Is that something where the officer was still applying for a warrant, even though there was no yes or no?
And I believe that's covered in 1202. So if you bear with me, I'm just gonna, but I think that there's language that essentially if someone is incapacitated or unresponsive, there is an ability to do that. So just bear with me, to pull up that language. Yeah, so in 1202A2, the blood test portion, there is a provision that says if in the officer's opinion, the person is incapable of decision or unconscious or dead, it is deemed that the person's consent is given and a sample of the blood shall be taken, but you still need to go through the warrant process to that.
Still need the warrant.
Yes, because the final sentence in that is a blood test sought pursuant to the subdivision shall be obtained pursuant to subsection F of this section, subsection F is the warrant requirement.
And that was the gist of my question, through the inability of them to consent or not. Okay, they
You
still need the warrant.
You still need a warrant, but they've essentially consented, but I think it's sort of a belt and suspenders approach in that regard, the way the law is designed. But you still need the warrant and you don't need consent for the blood draw per se.
Because there's one. So in regards to this section, I mean, would it? I mean, it almost seems like a moot point. This,
I mean, I was thinking about some language that you do. So if you look on page 5, subsection J, for instance, right? It says the person suspected of violating this section shall not refuse to submit. You could say shall submit. And that way you're not talking about refusal, which is sort of the opposite of consent. So you're kind of making a distinction based on the language itself. And then when you look at in subdivision D6, there's the new addition of subdivision C on page 9, where the person, and this is what creates the criminal refusal crime, a person refuses the collection, so you could just say does not submit to the collection of a blood sample. So something again where you're not getting into that refusal language.
What line you on, Madam Clerk?
That's line 7 on page 9. So rather than saying refuses the collection, you could just say, or shall submit, or something to that effect.
yeah, I think if we put hinders the collection of that measure sample. Well,
What about impedes?
Would there be a difference in either of those words?
I mean, hinders, impedes, disrupts. I think when you think of hindrance versus impediment, I think a hindrance might be more like something that requires action rather than an impediment. But it could be the other way since I'm, thinking on the fly, right? So I could look into the difference between the words, but that language does harken back to what's currently used in that obstruction of justice or hindering arrest language, which really is sort of about something that the person does to prevent the investigation of a crime. I think there's a potential that if you say just does not or that fails to submit as opposed to hinders, failing to submit is sort of an omission of action. Hinders or impedes requires some sort of commission of action. I think if you distinguish it that way. So does that then create sort of another sort of actus reus element, like another kind of conduct element in that impediment or hindrance? And if that's something the committee wants to have, that's your prerogative. Or if you want it just to be, they don't submit, to the test at all, rather without having some sort of comment attached to it.
Mhm. Yeah, I mean, I just don't wanna sweep up the person, you know, sitting there to just say, and the cop shows up with a warrant and they say, we're gonna draw your blood, and the person says, I don't really feel comfortable with that. But then they put their arm out and they say, all right, fine. Is that, I don't think that warrants, being charged with criminal refusal. Because, I mean, one, there's a warrant, so the consent doesn't matter, but, if somebody is fighting with the nurses and, doing everything in their power to avoid getting their blood drawn, I think that certainly warrants, criminal refusal. So, with if the language of, if we were to put that they do not submit, do you think that would broaden, everybody gets scooped up in this?
Well, meaning like medical personnel or just,
No, just the person who, like the first example of the person who says, I don't feel comfortable doing this, and the cop says, well, I've got a warrant, and they don't really say anything, but they put their hand out or their arm out. They're not submitting initially. I don't know if that's the best example.
yeah, no, I mean, I think what you're getting at is essentially like if they're almost just apathetic about it,
Yeah.
as opposed to like actively kind of fighting it. I do think that a failure to submit would probably broaden it, so it could capture more conduct, as opposed to hindrance or impediment.
So the hosting.
I still. So first of all, I would imagine that if someone was fighting with nurses, they could be charged with assault, they could be charged with disorderly conduct. Like there's all a number of things that are problematic in that behavior that is already criminalized. So I'm a little, I'm concerned about this bill as a whole, frankly. I have concerns with treating human bodies the same as buildings. I have a concern with sort of the constitutional question in here, and it sounds like other states deal with this in different ways. So to me, creating a new crime that is covered by other crimes is just problematic. It's not really a question.
Well, but so you're right in that the other crimes can get to this conduct. However, there a lot of the discussion in House Judiciary was keeping sort of the DUI related conduct within the DUI umbrella of sanctions and rehabilitation to try and those other laws that could cover that conduct that you were mentioning can absolutely be used, but they're felonies. They enhance the penalties and they don't have the rehabilitative aspects of the DUI related crimes, which this would include.
I hear that. I guess what is the need to, I just don't understand the need to just charge with DUI. Like,
I think the alternative or the issue is that, they're getting charged with DUI, but then they're also getting charged with non-DUI related felonies, which are much worse and, rather than the misdemeanor criminal refusal.
And this goes to the investigation to gather the evidence to potentially support a charge of a DUI. Because this is when, you pursue blood tests when there are either drugs present or breath testing equipment's unavailable, or the person's unable to provide a breath sample. And so the evidence, the blood sample is the evidence to determine whether or not they're actually intoxicated.
And my concern, and I could be totally left field on this one, is once they're there, going to Senator Hoskins' comments, is they may revert back to the fruit of the poisonous tree if we don't address the original intent as to why they were there. Then anything that happens after that, could that be challenged if we don't address the original?
Potentially, I mean, it's all a fact.
Anything's potential.
Yeah. And again, this doesn't go, it still preserves the right to challenge the validity of the search warrant itself. And so that's another remedy, so to speak, that the subject would have. But this is part of the evidence gathering process, I suppose. And could there be for the poisonous tree implications if it's not done properly? Yes.
Justification for someone to be in custody, I mean, that.
Right, yeah, so all those tools would still theoretically be available if the facts won't, supported it. But, as far as this specific language, it's kind of a policy decision as far as the type of conduct you want to potentially sweep in. And then also, in my view, this wouldn't reach the medical practitioners and their conduct. This is the subject. And that's also kind of theoretically another stopgap that even with this change, I don't think that there's been testimony to say it would change what a nurse or a doctor or other technician would do if they don't have the patient's consent, because they still have their own standards and ethics that they uphold. So this is really just about law enforcement of the subject. I don't think it would really have an impact on what doctors and nurses do.
So what are we trying to accomplish here on page 9 then?
First question for the house.
So page 9 is what creates criminal refusal for failing to collect the blood samples pursuant to the warrant. And then that is tied to the previous portion on page 5, the addition of subsection J towards the bottom, starting on line 13. This creates the requirement that they submit to a warrant-based blood sample. That also preserves their right to challenge the validity of the search warrant.
Okay.
So they work in tandem.
Yeah, the thing that, the submission to the warrant is irrelevant though, because there is no consent that's needed because there's the warrant. So maybe I'm confused, but I think Senator Norris, to your point, I think the underlying question of what problem is this trying to solve is the issue that somebody who is refusing to submit to the warrant is getting charged with felonies that are not related to the DUI, whereas ordinarily somebody who is refusing to provide a breath test, they get charged with a misdemeanor criminal refusal. And then there's also the corresponding license suspension.
But this doesn't really affect that.
Doesn't affect that, okay. So,
But the way you framed it, Senator Sheen, I think is accurate from the testimony in the House.
And obviously on page 5, subsection cannot be construed to personally challenge the validity of the warrant. The only reason they're going after that is because, in fact, even though they do submit the blood test, if the warrant is thrown out, then so they have to follow. Right? That's what this is. Even then, they have to do.
But it requires more litigation. And that would probably be handled, again, instead of proceeding to challenge the warrant itself or the evidence that came from it. So motions to suppress.
my inclination is to make this more specific for somebody who is not submitting when there is a warrant issued, or if they're, physically hindering the process. But, considering what we talked about with the invasiveness and the implied consent for blood draws, I don't think that it should be applicable. I don't think it can be applicable for declining consent when there's no warrant. So that's my, I don't know if that requires any wordsmithing.
Well, so I guess that's just the question that I have for the committee is, do you want to kind of make that distinction in wording to remove that sort of refusal language? And you could do that in a couple of ways. You could do that by that sort of the suggestion of, you could say, if you fail to submit, or you could do hindrance or impediment or some sort of, action-based word.
What does the committee think?
I like your original under C, shall submit to an evidentiary blood thing.
So do we refuse to,
Yes.
just say shall submit to?
Shall submit. I mean, it appears, according to Ledge Council, that most of the warrant has been issued. Consent isn't needed. It's two separate issues. Consent isn't needed no more. So
That
shall submit.
might be, I think that there's overlap of the concepts, but I think the way that they're analyzed under the law is different. And I think that the current statute and language in it recognizes that distinction. And the reason why I say that is because I believe it's subsection F on 1202. So again, on that page 9, that once, and so if you look on line 20, once a law enforcement official begins the application process for a search warrant, the law enforcement official is not obligated to discontinue the process, even if the person later agrees to provide the evidentiary sample. I think that language itself almost recognizes the conceptual difference. It's saying, well, you're already going through the warrant process because, and if you obtain a warrant, you don't need consent. And so even if that person consents, you don't need to stop the warrant process.
Because you can do, they can say, no, I don't want to do it again. And say,
Yes, you can withdraw consent later.
Yeah.
It's with, I'm sorry. No, you go ahead. Can you withdraw consent after the test is taken? Or is that too late?
I'd have to double check that, but my instinct is that it's too late at that point.
Yeah. Yeah, I don't see.
Yeah, I don't see what the basis for
Yeah.
it would be at that point.
So just to paraphrase or summarize again, that change on page 9 were to be that the person shall submit to the collection of an evidentiary blood sample when a warrant is issued. That will differentiate between the person who is almost apathetic at first or
I think it would include that.
and so that person who's apathetic or hesitant, they're also going to get charged with criminal refusal.
Well, that might be something. So this is, the obligation that you must submit. The criminal refusal is in the next portion of the bill. So I don't know if that's where you want to create the distinction between sort of that apathetic individual that doesn't really say, that might just keep their arms crossed rather than holding it out. And someone that's actively kind of resisting it, the collection.
Yeah, I prefer distinguishing between somebody who's just being apathetic versus somebody who's trying to disrupt the process. I mean, if there's a warrant, you're the subject of that warrant. I mean, fighting back is one thing, sitting there and not doing anything.
So, and I think on that, so subsection J, I think creates the obligation on the individual to submit, right? It's that next portion on page 9 that creates the criminal refusal. So what you could do is that this affirmative obligation here is that if you want to say everyone must submit, that's the expectation. And then to create the criminal penalty for someone that, and this might create a gap between the obligation and what's criminalized, with the other section with the hindrance or impediment.
Yeah,
So I don't know if that's what you're getting at.
that is what I'm getting.
Okay.
That's what I would prefer. Any thoughts?
I guess you'd have to explain that to me again.
So
Definition, I mean.
So if you look at subsection J is what kind of creates the investigative expectation, for lack of a better term, where, okay, we get a warrant, we need to submit to the warrant. That's the expectation. Subdivision D6C, so on page 9, that's what creates the criminal refusal crime. And so do you want to create sort of a gap where you have the expectation that everybody submits, and that's J. And then what you've criminalized is someone that doesn't, if you want to make the distinction that we're going off of based off of Senator Sheen, here, you could say hinders or impedes the collection. So there's sort of a gap between the expectation and what's actually criminalized. So you could say everybody needs to submit to this, but we're only going to criminalize some impediment or hindrance to the collection. So if you're sort of that apathetic individual, it leaves a gray area.
I can go along with once the warrant has been obtained, that everyone needs to agree to this and they think just as a refusal. And then any action that happen after that by is hindrance or all the above.
To kind of create that conduct-based action.
No, in the case you use, they're apathetic, and all I'm saying is they can or they can't. But if they physically,
So, yeah, I think to distill it further, you got the category of the person who, after the warrant's issued, person who's just saying, okay, you've got a warrant, I'm not doing anything, but here I am. Versus the person who plans up, puts their arms like this and, runs away. That second person, I think the misdemeanor criminal refusal is appropriate. First person who's apathetic or maybe they're just scared of needles. I don't think that an additional crime is warranted for that person. And so that's what I'm trying to.
or the additional crime, if they sit there and say, okay,
And then you take the
you take their blood, where's the additional crime there?
I agree.
Right. So I can go along with that. They're gonna do that.
Yeah.
I think it's a fine line, in my opinion, but I certainly can.
It's a distinction that you can draw though.
Yeah.
Any other thoughts?
Back on page 5 with J there,
Mhm.
do we have to spell out on that last sentence, this subsection shall not be construed as impairing a person's right to challenge the validity of a search warrant in subsequent legal proceedings when consent is not given? Because I heard before, if you give consent, you waive that right.
But there are a lot of reasons a warrant can be challenged, not just based off of consent.
Oh, okay.
Yeah.
Okay.
And consent even is also often challenged.
Right.
If there's a large presence of law enforcement and, there's 6 cops surrounding you.
It's sort of that
you're just like,
coercive effect. It's like,
Okay.
you need to do this because look at all of it, so there are
So
a lot
just
of-
because you give consent doesn't mean you waive that right.
Exactly.
Down the road. Okay.
Right. So, and that goes to my point of the concepts overlap, but
Yeah.
can be separate analyses.
Okay.
Okay, so for J, say shall submit. And then for D6, C, it would be or hinders the collection of an evidentiary, for
Yeah,
example.
I think that's it.
So do we change C to just take on line 7?
So with C, what we did is that we struck refuses and added hinders.
Oh, so it's not shall submit to an evidentiary blood sample?
That's on page 5, I think you're talking
Yeah,
about.
are you talking about
I'm
nine?
on page 9, line 7.
Yep, so that's subdivision C.
Yep.
Yeah, so right now it reads refuses the collection of an evidentiary blood sample. Refuses would be struck and it would read hinders the collection.
Hinders.
So hinders means you're doing something, right? There's an action.
In my view.
Yeah, that's how I would see it. Yeah. Then I only want to take up 5 more minutes here because I know Senator Morris has to go somewhere. But there was another piece. Well, actually, before we move on, are there any other additional comments or thoughts before we move on to the next meeting? Okay. Another piece that was provided by Wade Cochran, I think it was yesterday.
Oh,
And I don't.
Oh,
I didn't
that's
understand.
the anti-masking.
Yeah, I'm not sure if fully grasped that. Or is that
Yeah,
something-
I looked into it a little bit. I'm still wrapping my head around it. But I think basically it's for those drivers that are under 18 versus ones that are over 18. And since, I think really it would be those youthful offenders, the ones that are, 18 and maybe 19, depending on when it goes into effect. That would potentially be captured by the issue raised. But I mean, maybe I could reach out to counsel at the DMV to just get a better sense of what the issue is, and then I can loop you in and work on some language and then submit it.
I think that's
That's a CDL thing.
Yes.
Yes, there was a permit for a CEO. But you got your license.
You just,
then
you go out there and drive around?
No, you got your Vermont license. So now you just go through the commercial drivers, like with the training course. I didn't know there was a permit process for a CDL,
Well, how do you drive on the road if you don't have a license?
And like I said, you
I
got
think
your
we
license.
can.
That doesn't cover a commercial motor vehicle.
So I'll make the changes we discussed. I'll contact DMV council and just get some clarity on